public. And today, the Supreme Court has answered that question by a vote of 6-3.
The most significant case regarding the Second Amendment in more than a decade. The ruling could jeopardize similar laws in 5 other states.
Everybody has a right if they're a responsible adult.
While the entire nation was glued to their screens watching political theater and the latest celebrity meltdown, something absolutely monumental happened in Washington, D.C., and I'm willing to bet you heard absolutely nothing about it. In June 2025, the United States Supreme Court issued a ruling so unanimous, so decisive, that it made history. 9-0, not 8-1, not 7-2, 9 justices, liberal and conservative, standing in complete agreement on a case that could fundamentally reshape gun laws across America. Here's the twist that'll blow your mind. The ruling didn't even mention the words gun control. It was technically about whether Mexico could sue American gun manufacturers for cartel violence. But buried inside that decision was a single sentence, just one carefully worded line, that legal experts are now calling the biggest threat to state assault weapon bans in American history. From California to New York, from Illinois to Connecticut, anti-gun lawmakers are quietly panicking, and the mainstream media, they've gone completely silent. But we're not going to let this story disappear, because what happened in that courtroom affects every single gun owner in America and possibly determines the future of the Second Amendment for generations to come. Let's dive into the case that's about to change everything. The story begins in 2021 when the Mexican government decided to take an unprecedented legal gamble. They filed a lawsuit against some of the most recognizable names in the American firearms industry: Smith & Wesson, Glock, Colt, Ruger, and several others. The lawsuit wasn't small. Mexico was demanding over $10 billion in damages. Their argument was bold and frankly controversial. Mexico claimed these companies were knowingly fueling the horrific cartel violence devastating their country by allowing firearms to be trafficked across the border. But here's the critical detail. They weren't claiming the gun manufacturers broke any laws directly. Instead, they were attempting to hold these companies legally responsible for crimes committed by completely different people.
My response to that is that's the same claptrap that they have been using for 20 years.
You couldn't get a firearm and carry it just because you wanted to be protected against criminals. We won't see changes overnight, but it's going to be quick.
And today, the Supreme Court said that's unconstitutional. That puts a limit on the right to have a gun.
The smugglers who transported guns illegally, the corrupt dealers who facilitated the transfers, and ultimately the cartels who used these weapons in unspeakable acts of violence. It was essentially a legal Hail Mary pass, an attempt to use American courts to force U.S. gun makers to pay billions for violence happening in another sovereign nation. The case worked its way through the lower courts, drawing international media attention and heated debate. Initially, a district court judge dismissed the entire lawsuit, citing a 2005 federal law with a lengthy name but enormous importance, the Protection of Lawful Commerce in Arms Act, commonly abbreviated as PLCCAA. This law, passed by Congress 2 decades ago, was specifically designed to protect gun manufacturers and firearms dealers from being sued when their legally sold products are later misused by criminals. The logic is straightforward and mirrors how we treat every other industry. You can't sue Ford because someone deliberately drove their car into a crowd of people. You can't sue a knife manufacturer because someone committed a stabbing. And under PLCCAA, you can't sue a gun company because a criminal used their product to commit a crime, as long as the original sale was lawful. But Mexico wasn't ready to give up. They appealed the dismissal, arguing their case deserved to be heard. The appeal moved up through the judicial system, gaining momentum and attention, until it finally landed on the doorstep of the highest court in the land, the United States Supreme Court. And then came June 2025. In what can only be described as a rare moment of absolute judicial unity, the court issued its ruling, 9-0, unanimous. Every single justice, from the most conservative to the most liberal, stood together with one voice. The message was crystal clear: no, foreign governments cannot weaponize American courts to attack American businesses for crimes committed by others in their own countries. The gun manufacturers had won, completely and decisively. Gun rights advocates celebrated. The firearms industry breathed a collective sigh of relief.
The Second Amendment. The Supreme Court struck down a New York law that required people to show a special need to carry a concealed gun in public.
Major Supreme Court ruling on New York's concealed carry regulations.
Mexico's audacious legal strategy had failed spectacularly. Case closed, right? Not even close. Because what happened next is where this story transforms from a simple victory for gun manufacturers into something far more significant, something that could reshape the entire landscape of American gun legislation. Buried inside the Supreme Court's 25-page opinion was a sentence that, at first glance, might seem unremarkable, but legal scholars immediately recognized it as a constitutional earthquake. The sentence wasn't written by Justice Clarence Thomas, despite many initial reports incorrectly attributing it to him. It was actually penned by Justice Elena Kagan, generally considered one of the court's more liberal voices, who authored the unanimous opinion. Here's what she wrote. Firearms like the AR-15 are widely legal and commonly owned by law-abiding citizens for lawful purposes. This isn't just an opinion or a passing observation. This is a binding factual finding issued with the full authority of the United States Supreme Court, specifically addressing the AR-15, the single firearm most frequently targeted by so-called assault weapon bans across the country. Why does the phrase common use matter so much? To understand the explosive power of these words, you need to know two landmark Supreme Court cases that redefine Second Amendment law in modern America. The first is District of Columbia versus Heller, decided in 2008. The second is New York State Rifle and Pistol Association versus Bruin, decided more recently. In both cases, the court established a straightforward but powerful legal standard. The government cannot ban firearms that are in common use by law-abiding citizens for lawful purposes. Let me break down what this means in practical terms. It doesn't matter if a firearm looks intimidating. It doesn't matter if politicians give passionate speeches about how dangerous they believe it is. It doesn't matter if the gun has been misused by criminals. What matters, according to the highest court in the land, is whether that firearm is commonly owned and regularly used by ordinary, law-abiding Americans for legitimate, lawful activities. Now let's talk numbers, because numbers don't lie, and they don't care about political narratives. According to the National Shooting Sports Foundation, as of 2025, there are more than 24.4 million AR-style rifles in civilian hands across the United States. Let me give you some perspective on how massive that number actually is. There are more AR-15 rifles in American homes than there are Ford F-150 trucks on American roads. Think about how often you see an F-150. Now realize there are more AR-15s than that. These rifles aren't being hoarded by extremists or stockpiled by criminals. They're owned by teachers, nurses, veterans, small business owners, farmers, and suburban parents. They're used for home defense, competitive shooting sports, hunting, and recreational target practice. All clearly lawful, constitutionally protected activities. So when Justice Kagan wrote that the AR-15 is widely legal and commonly owned, she wasn't being poetic or expressing a personal viewpoint. She was stating an objective, verifiable fact backed by mountains of data. And in doing so, she planted what legal experts are calling a constitutional landmine directly underneath every single state-level assault weapon ban in America. Here's why this sentence is so devastating to gun control laws. Right now, legal teams across the country can walk into courtrooms in California, New York, Illinois, New Jersey, Connecticut, and every other state with restrictive gun bans, point directly to this Supreme Court ruling, and make an airtight argument that goes like this. Your Honor, the Supreme Court has already determined that these rifles are widely legal and commonly owned for lawful purposes. Under Heller and Bruin, that means they're constitutionally protected. The state cannot ban them, period. It's not speculation, it's not wishful thinking. It's a direct application of established Supreme Court precedent, now reinforced by the court's most recent unanimous declaration. This is why gun control advocates have gone eerily quiet about this ruling. This is why mainstream media outlets that usually jump on any gun-related story have barely mentioned it, because they understand exactly what it means. That single sentence may very well be the death knell for assault weapon bans across America, and the legal dominoes are already starting to fall. Take California, often considered ground zero for the nation's strictest gun control legislation. One of the highest profile legal challenges is Miller versus Bonta, where federal judge Roger Benitez struck down California's Assault Weapons Control Act, declaring it blatantly unconstitutional. His reasoning was surgical in its precision. The state cannot ban firearms that are demonstrably in common use by law-abiding citizens for lawful purposes. Does that reasoning sound familiar? It should, because it's exactly what the Supreme Court just confirmed in its 9-0 ruling. Now, attorneys challenging California's ban and similar laws in other states have nuclear-level ammunition. They're marching into courtrooms armed with a Supreme Court decision that explicitly states AR-15s are widely legal and commonly owned. They're asking judges a simple, devastating question. If the highest court in the entire country recognizes these rifles as lawful and common, On what possible constitutional grounds can any state claim otherwise? It's a legal battering ram, and it's already cracking the foundations of gun bans that have stood for years, even decades. But the opposition isn't going down without a fight, even if that fight is increasingly desperate and disconnected from legal reality. During oral arguments in Miller versus Bonta, Ninth Circuit judges displayed levels of confusion that would be comical if the stakes weren't so serious. One judge repeatedly referred to the AR-15 as a machine gun, despite being corrected multiple times by attorneys who patiently explained that AR-15s are semi-automatic, firing 1 round per trigger pull, not fully automatic machine guns, which have been heavily regulated since 1934. Another judge called it an A-15, seemingly unable or unwilling to even pronounce correctly the name of the firearm he was supposed to be ruling on. Even more troubling, some judges floated the legally absurd argument that constitutional rights might somehow vary by state. They suggested that a rifle protected under the Second Amendment in Texas could simultaneously be banned in California. That's not just bad law. That's a fundamental misunderstanding of how the Constitution works. Imagine if judges suggested your First Amendment free speech rights change depending on your zip code, or that your Fourth Amendment protection against unreasonable searches only applied in certain states. It's not just wrong, it's dangerous. Yet that's the tortured logic being deployed to defend these increasingly indefensible bans. These reactions aren't merely misinformed, they're desperate. They reveal a judicial class scrambling to preserve laws that are now legally untenable, exposed by the Supreme Court's clear, unambiguous declaration. And this isn't just about California. Right now, 10 states plus Washington, D.C. have their own versions of assault weapon bans, most using remarkably similar language to restrict popular rifles based largely on cosmetic features like pistol grips, adjustable stocks, or flash suppressors, features that have absolutely nothing to do with how dangerous a firearm actually is. But the numbers tell a story that politicians don't want you to hear. In Illinois, a sweeping ban passed in 2023 affects over 2.4 million lawful gun owners. In New York, compliance with the SAFE Act has been dismal, with less than 15% of affected firearms ever being registered. In Connecticut, out of an estimated 372,000 rifles that the ban supposedly covered, only about 50,000 were registered during the mandatory period. What we're witnessing is a massive nationwide disconnect between restrictive gun legislation and actual citizen compliance. Millions of law-abiding Americans are simply refusing to comply with laws they view as unconstitutional infringements on their rights. And now, armed with this Supreme Court ruling, federal courts are starting to take notice. Judges can no longer ignore the facts. These rifles aren't exotic weapons. They aren't rare or unusual. They're mainstream, they're common, and according to the Supreme Court, they're constitutionally protected. So where do we go from here? The path forward is becoming increasingly clear. Expect a massive wave of new legal challenges. Lawsuits are already being filed or revived in Illinois, New York, Maryland, New Jersey, Massachusetts, and every other state clinging to assault weapon bans. These aren't fringe legal efforts led by small-time activists. They're backed by major legal organizations with deep resources, represented by top Second Amendment attorneys, and they're landing in front of federal judges who now have crystal clear guidance from the Supreme Court. This ruling accomplished something that goes far beyond simply protecting gun manufacturers from frivolous foreign lawsuits. It sent a loud, unmistakable message that echoes through every courthouse in America. AR-15 and similar rifles are in common use. They are legal, and they are protected by the Constitution. The notion that a state government can override that constitutional protection because of political pressure, emotional rhetoric, or media hysteria, that era is rapidly coming to an end. Because here's something that gun control advocates consistently forget or deliberately ignore. In the United States of America, your constitutional rights don't stop at state borders. The Second Amendment applies in California just as much as it applies in Texas. The Constitution isn't a menu where states get to pick and choose which rights they'll honor based on the political preferences of their legislators. This is the defining fight of our generation when it comes to the Second Amendment. This ruling represents more than just a legal victory for gun rights. It's a critical step toward restoring the Second Amendment as it was originally intended, as an individual right that shall not be infringed. It confirms what millions of Americans have known all along. Rifles like the AR-15 are lawful, they're common, they serve legitimate purposes, and they're constitutionally protected. The manufactured panic, the misleading terminology like assault weapon, the focus on cosmetic features rather than actual function. All of it is exposed as the political theater it always was. We're standing at a crossroads between genuine constitutional freedom and creeping government control. The Supreme Court just handed us a roadmap toward freedom. Now it's up to every gun owner, every Second Amendment supporter, and every American who values their constitutional rights to make sure this momentum continues. If you believe in protecting your rights, now is the time to act. Subscribe to this channel so you never miss critical updates. Share this video with everyone who needs to understand what's really happening in our courts. And drop a comment below with your thoughts. Is this the beginning of the end for assault weapon bans, or just the opening salvo in an even bigger constitutional battle? Either way, we'll be right here, covering every development, analyzing every court decision, and making sure the truth doesn't get buried under political spin and media silence, because your rights are worth fighting for, and this fight is far from over.